Good day. My name is Mark Mellor. I'm an attorney here in Riverside, California. I got a number of business clients in Needles, California, dealing with opening up a new corporate or business entity to insulate them from personal liability. And so I thought it helpful to put together a quick video on some of those business entities you might want to consider forming to protect yourself and to give you favorable tax treatment in your business. Those business entities are S corporations, C corporations, and limited liability companies, or LLCs. Now, what's the difference between them? Well, the first thing that you need to realize is regardless of the entity you choose of those three, they all give you personal liability protection in your particular line of work. So that means that a person, a disgruntled client, or somebody dealing with your business can't sue you individually for work that the corporation did. Assuming we don't have issues of fraud involved or commingling, you're personally protected from individual liability, meaning your house is okay, your stocks and bonds, your bank accounts are okay personally. The next thing we need to think about is in terms of tax treatment. For that, you want to see your CPA or tax professional to determine in your particular line of work what the most favorable tax treatment for a business entity you're going to form is going to be. There may be tax deductions or tax treatment involved in a particular entity that don't apply to the other that you want to form for that reason. And once you get that analysis, you would come to my office and we would form that particular entity. But third, you want to take a look at some of the differences between them, those entities. The first being that in issues of like real estate, for example, I have a number of investor clients that use LLC entities for their real estate holdings because they get more favorable tax treatment. And that's an incentive for them to use an LLC for that purpose. A corporation doesn't suit that purpose because of the tax treatment involved, and so they don't choose to do that or be run by the corporation's code. The second thing to pay attention to understand about the difference between the two is that an LLC is governed by an operating agreement, which you write up or your attorney writes up for you. A corporation is governed by the corporation's code, which is codified by the California legislature. The third, you want to make sure that you understand the difference between the two corporate entities, S Corp and C Corp. For example, an S Corp has different restrictions than does a C Corp, and they're treated differently tax-wise. For example, a C Corp has double taxation, meaning the corporation is taxed on the income it receives, and then it's also taxed when it devolves that income to the shareholders, hence double taxation. Whereas a S corporation receives income, it's taxed much like a partnership. That income flows through the corporation, gets expensed out, and then when it's devolved to the shareholder pays tax on its K-1 with its 1040 form, and you have singular taxation as a result. There are some restrictions with an S corporation because of that favorable tax treatment. That is that, for example, you can't have more than 500 shareholders. You can't have corporate shareholders, meaning another corporation can't own shares. Got to be individual shareholders. In some limited circumstances, you can have trusts own shares. But that's very limited circumstances, very rare to encounter that at all. Nonetheless, for individual liability protection and tax treatment, you want to think about forming a business entity, help protect your personal finances and your individual finances from liability, and also to get the favorable tax treatment. If you have any questions about your particular circumstances, feel free to give my office a call and I'd be happy to sit down with you and talk with you about them.